Welcome to Civil Procedure. This video is going to cover general jurisdiction, and the case that we are going to use to apply the general jurisdiction doctrine is Daimler AG versus Bauman. Asahi and Daimler both test fairness boundaries of the Due Process Clause in personal jurisdiction, but they do so in very different contexts. In Asahi, the lawsuit began with a U.S. plaintiff, California domiciliary, injured in California. The subject of the lawsuit in Asahi was a tort that occurred inside the state of California. As such, California had an interest as a forum state for the resolution of that lawsuit from the beginning. Now, after the California domiciliary settled their portion of the lawsuit, the case collapsed into a dispute between two foreign corporations. That's a foreign third-party plaintiff, who was one of the original defendants, and a foreign third-party defendant who also was one of the original defendants. But that's what we had left to resolve the case that was filed in California. Now, Daimler, on the other hand, was an international case from the very beginning. We have foreign plaintiffs who sought to sue a foreign defendant for alleged human rights atrocities in a foreign country. None of the parties nor the underlying conduct had any connection to the state of California. To connect the foreign defendant, that's Daimler AG, to California, the foreign plaintiffs relied on Mercedes-Benz USA. Mercedes-Benz USA was a Daimler subsidiary that was located in the United States. Now, as the Mercedes-Benz distributor for Daimler AG in America, Mercedes USA had extensive contacts in California. But here's an issue. Mercedes USA was incorporated in Delaware and headquartered in New Jersey. Okay, so just hold on to this because we're going to get a little deeper once we get into the facts. But this is really just trying to shape the landscape. Mercedes-Benz USA did, in fact, have offices in California, facilities in California, and strong sales in the state of California. Daimler AG says that Mercedes-Benz USA had the largest U.S. market in California. So there's no question that there's activities taking place in California as a result of MBUSA's presence in California. However, MBUSA was not the co-defendant. MBUSA was not the subsidiary that was accused of wrongdoing. The Daimler AG subsidiary that was accused of wrongdoing was Mercedes-Benz Argentina. And Mercedes-Benz Argentina had no presence in the United States as a whole or California specifically. That left the plaintiffs in a bind, right? The subsidiary with the California contacts, that's MBUSA, had no alleged misconduct in California, and the subsidiary with the alleged misconduct, that's Mercedes Benz Argentina, had no California contacts. Furthermore, while both Mercedes Benz USA and Mercedes Benz Argentina were subsidiaries of Daimler AG, as subsidiaries, they were independent of each other. Yeah. So the foreign plaintiff's theory was this: if we could impute MB USA's activities in California to Daimler AG, right, we may be able then to substantiate through MB USA that Daimler AG has enough activity for it to be considered systematic and continuous. What's the problem? What's the problem? 3 years earlier, in 2011, we already had a case that says systematic and continuous for general jurisdiction wasn't enough. The foreign defendant had to essentially be at home. So, what is the Supreme Court going to say at the end of Daimler? At the end of Daimler, the Supreme Court is going to say that the foreign plaintiff's attempt to end run the necessary requirements to substantiate general jurisdiction were exorbitant. Yeah, that's what the Supreme Court is going to say. This opinion is given by the Honorable Justice Ginsburg. So while Asahi began domestically and collapsed into a foreign to foreign dispute, Daimler began as a foreign dispute. Nonetheless, as we said in the beginning, both cases pose the same due process question, and it's this: can a United States forum fairly exercise general jurisdiction over disputes with so little connection as what either Daimler AG has to California, or as an Asahi, as a Taiwanese tire company and a Japanese valve company had to California? Well, let's check out the procedure history. Pretty clean. Back to Daimler. Bauman, who is the foreign plaintiff, and other Argentinian plaintiffs, in fact, there's 22 of them, sued Daimler AG. Daimler AG is a German corporation, incorporated and headquartered in Germany. Can Bauman, who is a foreign plaintiff, 22 of them, sue a foreign defendant in federal court, California, for alleged human rights violations committed by Daimler AG and Daimler AG's Argentinian subsidiary, Mercedes Benz Argentina? The Argentinian plaintiffs filed suit in federal district court in California, Northern District. The federal court dismissed the plaintiff's lawsuit for lack of personal jurisdiction. The plaintiffs appealed. The Ninth Circuit affirmed this dismissal, right? And upon reconsideration, upon reconsideration, sitting en banc, that's a full panel, the Ninth Circuit reversed their previous holding and held that the contacts that Mercedes-Benz USA has with the state of California was going to be enough for the court to exercise general personal jurisdiction over Daimler AG and Mercedes-Benz Argentina. Case went up on a petition for certiorari. The Supreme Court reverses the Ninth Circuit reversed holding, and the United States Supreme Court held that Daimler was not at home in California. And because Daimler was not at home in California, the federal court sitting in the Northern District of California had no authority. Don't you just love how it all comes together? It just all comes together. The Daimler fairness question. Here it is. The key question in Daimler was whether a federal court sitting in the Northern District of California could exercise personal jurisdiction over Daimler AG, a German corporation headquartered in Germany. Foreign plaintiffs theory, clearly not specific jurisdiction. Not specific jurisdiction. Why not? Because Daimler AG had no contacts in California. And if Daimler AG had no contacts in California, the alleged atrocities that took place during the dead wars in Argentina, right? These are the atrocities that are the subject, are the reason for this lawsuit, could not have arisen out of the contacts in California. Because there were no contacts in California. Instead, what the foreign plaintiffs attempted to do was to say, Mercedes-Benz USA is an American subsidiary of Daimler AG. Mercedes-Benz USA has a lot of contact in California. There's a lot of activities going on in California. And as a subsidiary of Daimler AG, the foreign plaintiff wanted to utilize what they classified as systemic and continuous contacts in California, right, through Mercedes-Benz USA, and impute that to Daimler AG, thereby giving Daimler AG, through this imputation, systematic continuous contact, which they hoped would be enough to establish general jurisdiction. What is general jurisdiction? Well, we know because we were introduced to the concept of general jurisdiction and systematic and continuous contact way back in International Shoe. So general jurisdiction is not unfamiliar to us, but let's give it a definition. General jurisdiction allows a court to hear any claim, not just a claim that arises out of the activities in the form, any claim, right? Whether or not the claim is connected to the activities within the form. General jurisdiction, that's how I check the box for personal jurisdiction. Now, we're going to look at two different paradigms to establish whether or not this jurisdiction is going to work. There's one for corporations and there's one for individuals. For corporations, here's the paradigm. The state of incorporation, the state of incorporation. Where are you incorporated? You in the United States, you're going to see a lot of people or a lot of corporations are incorporated in Delaware, but that's question one. Where are you incorporated? Are you incorporated in the form state? No, you're not. Okay, okay. I can still get general jurisdiction. Let me ask this question. Where's your headquarters? Do you have a headquarters in the form state? If you have a headquarters, we can make that happen. Yeah? No, you're not incorporated in the form state, and your headquarters is not in the form state. You don't have an office where you have big business of the corporation happening in the form state, not just a regional office, not just a satellite site, but no. Well, then you're probably not going to reach general jurisdiction. Allow me this indulgence. When we are speaking of personal jurisdiction and we're speaking of corporations and we're speaking of general jurisdiction, we do not call the principal place of business the nerve center. It's wrong nomenclature. And I know that that might sound like I'm splitting hairs, but I'm splitting hairs. The nervous center, that term is a term that is specifically associated with diversity jurisdiction, specifically associated with diversity jurisdiction. So if a professional lawyer who's as obsessed as I can be about precision and accuracy, because I believe in the magic and the power of our words and our terms, if you say to them nerve center, they're going to think diversity, right? Because that's where that term is associated. Okay. All right. Jumping off the soapbox, get back to it. For individuals, what are we looking for to exercise jurisdiction for individuals? Because general jurisdiction is applicable to individuals as well. It's a little bit easier to teach it using corporations, but it's also applicable to individuals. So, what are the paradigms that I look at if I'm trying to see if a court can exercise general personal jurisdiction over an individual? I'm looking at either their domicile, or I'm looking at whether or not that individual was served personally inside the physical boundaries of the forum state. We have a term for that as well. That term is called tag jurisdiction. I call it Pennoyer 2.0. When I think of tag, I think of the game that I played as a child, right? Pennoyer 2.0 automatically takes me back to within the geographical boundaries, because that's what that is. Now, please allow me yet another indulgence and allow me to state the obvious. If the foreign defendant is served personally inside of the forum state, we don't have a hypothetical on personal jurisdiction, right? We might have a hypothetical about subject matter jurisdiction or venue or removal or remand or something else, but you're not going to be asked to analyze whether or not the court has personal jurisdiction if the facts are such that the foreign defendant was served with process in the forum state. It's not going to be a problem that needs to be analyzed because the answer is, of course they do. Of course, the court has personal jurisdiction if you serve the foreign defendant inside the state, right? When International Shoe came along and introduced minimum contacts and traditional notions of fair play and substantial justice, they didn't kick common sense out the door, right? So if the foreign defendant is served with this process inside of the physical boundaries of the forum state, the court in the forum state is going to have personal jurisdiction. Yeah. Just like if the defendant isn't foreign, but is a domicile, right, of that state, the court's going to have personal jurisdiction. If the defendant consents to the court jurisdiction, this is a foreign defendant, and I consent to the jurisdiction of the forum state court, then the court, right? So don't overlook what makes sense. Don't overlook what makes sense. So for individuals, how does the court get general jurisdiction? The court will get general jurisdiction over an individual if the forum state is where the individual is domiciled, or if the foreign defendant was personally served with process in the forum state. Now, domicile, we're going to get deeper into that when we get into diversity jurisdiction, but so that you have understanding about it now and you can prepare yourself with the understanding that this is going to be expanded, domicile is going to require residence and an intent to remain indefinitely. Okay. All right. Got that cleared up. Let's keep on moving. You know me, I like tables. So let's put all of it together. Okay. Let's put it side by side. For corporations, general jurisdiction is very narrow. They have to be essentially at home in their state of incorporation or where they have a principal place of business. That's what essentially at home means. What is Daimler reminding us of? And it's critical. Daimler is reminding us that while systematic and continuous activity sounds good, because it does help determine the depth of the relationship that is the result of the activities, it is not the test for general jurisdiction. The test for general jurisdiction is being essentially at home. And like I said, 2011, that doctrine was introduced in Goodyear, right? And 2014, 3 years later, in Daimler, we're going to make sure that you understand that this scope for general jurisdiction is very narrow. It's so narrow that we're looking at two paradigms to satisfy whether or not general jurisdiction can be applied. And that's the state of incorporation and the principal place of business. Okay. All right. We are moving. Let's keep on moving. Why don't we jump into Daimler? I think this is a really good time, right? Let's just go ahead and get into Daimler so that we can have the discussion and see how this, it's not a new idea, but see how this idea as it has matured and as it has come into its fruition as a doctrine is applied by the courts. Okay. I gave you a little bit of the facts already. I know you've already read this case. I know this is just a review, so we're not going to go into too much detail. We're just getting ready to jump in. Issue. This issue is a little bit longer than some of the other issues that we've worked with, but understand that everything that we do as a lawyer is guided by the goal of the thing that we're doing. Issue statements for exam essay writing are one thing, right? That's that 3 point, what is the rule of law that we're going to find the answer, right? What is the legal question that needs to be answered? And what of the facts that are so key, that are so triggering, that are so dispositive that if those facts didn't exist, we might have a different issue or a different legal question to answer, but it wouldn't be this one, right? NCB style 3 point issue statement. Yeah, yeah. Those issue statements for exam writing are extremely different than questions presented, aka issue statements for appellate litigation, which are very different from other type, right? So understand that the issue statements that we're building are issue statements for doctrinal learning, for andragogy, right? This is the adult learning methodology. But if you take appellate litigation, or if you go into appellate litigation, or even if you participate in moot court where you're writing appellate level briefs, you're going to find that the issue statement oftentimes is not this condensed. So I say that to manage your probable feeling of being overwhelmed, because this issue statement is a little bit larger than the ones that we've done previously. Under the Due Process Clause of the 14th Amendment, because that is the umbrella of the law that our answer is going to come from, may a federal court in California exercise general personal jurisdiction, right? Because now we're talking about the legal question. What's the question? Well, here's the question. May a federal court in California exercise general personal jurisdiction over a foreign corporation? And I just put in parentheticals Daimler AG, incorporated, headquartered in Germany, to give context, right? For alleged human rights violations committed abroad. And I put in parenthetical Argentina because I'm trying to give context. We've got a foreign defendant and we've got foreign abuses, right? May the federal court exercise general jurisdiction when the only alleged conspirator is a foreign subsidiary with no presence. We already know that we have a foreign defendant, and the sole foreign connection is a separate subsidiary that is not incorporated in Delaware and does not have a principal, that is not incorporated in California and does not have a headquarter in California. Hmm. Hmm. The defendant has no connection to the foreign state. Can a federal court exercise general jurisdiction? Right? Well, let's look at the facts. You know who the parties are, you know what the underlying conduct is, allegations concerned the dirty wars. I previously had called them the dead wars, and that's my mistake. The dirty wars in Argentina. We know that Daimler's Argentinian subsidiary, Mercedes-Benz of Argentina, right? So we understand this. let's keep going. There's some more facts. Here's the theory. Plaintiff is trying to assert general jurisdiction. There's no claim of specific jurisdiction. We've already talked about that. MBUSA, oops, went one too far. MBUSA is a separate incorporated subsidiary. We know that MBUSA has significant activity going on in California. Yeah. Um, and so my list of facts may be different than your list of facts, but for all intents and purposes, there's the facts. Got it? What do we do with those facts? Well, we're going to have to analyze those facts within the context of the rule and what is the paradigm that we are being given. What did Goodyear tell us in 2011 that is being specifically affirmed and narrowed here in Daimler in 2014? In order to exercise general jurisdiction over a foreign defendant, yeah, here we go, assuming, common sense, the defendant didn't consent, assuming, common sense, the defendant was not served personally in the forum state, assuming, common sense, that the defendant doesn't have property in the forum state that can be attached at the beginning of the suit for in rem or quasi in rem, right? Don't forget the common sense stuff, right? How can the court exercise general jurisdiction? The plaintiff will have to establish that the foreign defendant is essentially at home in the forum state. Two ways to do that: to establish that the foreign defendant is incorporated in the forum state, or establish that the forum defendant has a principal place of business in the forum state. Done and done. Yeah? All right. Because you know I like tables, and because you know I'm trying to get you to build your process of taking the elements, that's what's required, and wedding those to individual facts so that you can explain how this all works to satisfy the element or negate the element. I've been using in every case that we've gone over together a fact element chart. Yeah. Daimler AG was incorporated in Germany. That's a fact. That's a relevant fact. What paradigm I'm looking for is the foreign defendant incorporated in the forum state? Well, no. So the paradigm is the forum state of incorporation. Daimler's incorporated in Germany. So when I wed this fact with this element, what do I get? Not incorporated in California. So California is not paradigmatic form. How did the court use that in its analysis? Incorporation outside of California defeats general jurisdiction. This is what you are explaining step by step, bit by bit in your analysis. Right? So now do you see why your analysis section, your application section, your application of the rule to the fact can't be a line or two, right? Or three or four. it has to be this very layered, detailed explanation. Yeah, let's go to the next one. Daimler AG was headquartered in Germany. What rule am I applying to that fact? Where does that fact fit? Well, that fact also fits in the paradigm of form, principal, place of business. Okay, so when I wed those two together, what am I getting? Headquarters, I say don't use nerve center, right? But California is not the paradigmatic form. What does that mean? Principal place of business in Germany confirms that Daimler is at home in Germany, not in California. Oh, I see. Oh, I see. I see. Okay, let's skip down. MBUSA maintained a regional office in California. Which rule does this fact apply to? It's going to apply to the corporate presence, right? The corporate presence. That was right. Paradigm one is incorporation. And this paradigm two was the principal place of business. So we're looking at corporate presence. Yeah. What does the fact that MBUSA has a regional office in California, where is that going to apply? That's going to apply to the presence, the presence. Yeah. When I add those two together, what do I get? A regional office is an operational facility. It is not a principal place of business. So, how does the court use that in its analysis? Regional presence is not enough. Oh my goodness, is it making sense? Is it making sense? Right. So, here's the fact element chart. Spend as much time or as little time as you like with it, but hopefully I'm laying a tangible footprint map of what is it that I'm actually expected to do in my application section. You are expected to take those relevant facts and place them in one of the elements, wed them to yield an outcome, and explain what that means. Okay. All right. So, what is the rule of law that we get to? General jurisdiction over a corporation exists only where the company is essentially at home. The court identifies the paradigm forms as the corporation's state of incorporation and principal place of business. Yeah, simple rule. Court's analysis. Daimler is incorporated and headquartered in Germany. Plaintiffs sought to impute MBUSA's California contacts to Daimler. They failed. The court emphasizes that whether a corporation is at home is not determined just by volume. Just because MBUSA had a whole bunch of volume going on doesn't make California, where all of this volume was taking place, a principal place of business or the state of incorporation. The court reiterates that continuous and systematic business in the state by itself is not the test. What's the test? Being at home. Conclusion. We clarified the rule, general jurisdiction, only where the foreign defendant, if it's a corporation, is at home. We look at the state of incorporation. We look at the principal place of business, one or the other. The court rejected the attempted imputation of California's volume of activity, right? It rejected that. And the takeaway is Daimler narrows general jurisdiction. We have reached the end of our evolutionary arc for personal jurisdiction. So let's go back to the table that we kept. This is my brain, my processing, and I started it with you from the beginning. Hopefully, whether you have adopted this system of process to track the evolutionary arc, or whether you've come up with something brilliant of your own, I hope that you are learning as you grow in adult learning that ultimately it comes down to what you invest in the process is what you will yield from the process, right? We started with Penori v. Neff. We then went to International Shoe. From there, we went to Moulin, which focused on notice and service of process, right? We now know that due process requires that notice be reasonably calculated under all the circumstances to apprise the interested parties, right? That was our notice and service of process case. We then go to Hansen v. Dinkla, where we get our purposeful availment. We then go to Worldwide Volkswagen, right? Where the idea of purposeful availment is solidified. We then get to Burger King, and now in Burger King, not only do we get through the analysis of minimum contacts, but we also get the nitty gritty of these 5 fairness factors. Yeah. And then we go to Helicopteros, and we get a better understanding of general jurisdiction, what it is and what it's not. We go to Asahi, where we get a plurality opinion on the minimum contact issue, but we reach a unanimous opinion on the fairness factors. And then we ended with Daimler. I hope this helps. If not, reach out to me. Have a great one. I look forward to seeing you when we begin subject matter jurisdiction.